Welcome to Synergy's Subject Matter Expert Insight webinar series. This webinar is part of an ongoing series featuring Synergy's subject matter experts giving you thought leadership insights into issues that impact personal injury recoveries. During today's presentation, if you have questions, type them into the control panel where it says questions. If we don't have time for a live Q&A today, or your question isn't answered, a Synergy subject matter expert will contact you to provide answers to your questions. Before starting today's webinar, the following is a brief presentation giving you an overview of what Synergy does in 30 seconds. A trial lawyer's job isn't to know all the nuances of issues to be addressed when a case is over, to know what it takes to keep Medicaid in place or SSI, preserve Medicare and comply with the Medicare Secondary Payer Act, and resolve complicated liens that may be present when a personal injury matter is resolved. Liens like ERISA, Medicaid liens, Medicare conditional payments, MAO plan liens, FEBA liens, all of those issues are things that the trial lawyer or paralegal really doesn't have the time or relevant expert knowledge to deal with. They need an expert strategic partner that they can rely upon that can handle it without question. And that's exactly what Synergy is. It's why thousands of top personal injury firms turn to and partner with Synergy every single day.
Hello, welcome to Synergy's Medicare Secondary Payer Compliance in a Nutshell Expert Roundtable. During this presentation, you are going to hear from Synergy experts that are going to hit upon the three components of Medicare secondary compliance, and we will help you figure out how to avoid those MSP compliance traps. I'd like to introduce you to our experts. You will be hearing from Teresa Kenyon. She's our VP of Lien Resolution. She's an attorney with a great deal of experience in lien resolution. We also have Evelyn Pacino, another attorney. She is our Mass Tort Program Manager who has been in the space for quite some time as well. She's also a Medicare case specialist. Jasmine Patel is our Synergy Lien Resolution Manager. She's a Medicare case specialist who has a great deal of experience working on those liens, whether they're Medicare, Medicaid, or just straight up ERISA liens. My name is Rasa Fumagalli. I'm an attorney and I'm the Director of MSP Compliance here at Synergy. So I'm going to turn this over to Teresa so we can get started.
Thank you, Rasa. Let's definitely go ahead and just get started. We're going to start with the basics. So when does someone become eligible for Medicare? Evelyn, what can you tell us?
So there are two ways that someone can become eligible for Medicare. One is if they've worked 40 quarters or have a spouse who did, then they become eligible when they turn 65. If someone is under 65, then they can become eligible for Medicare through disability. So first they would receive Social Security disability benefits, and then after receiving that benefit for 2 years, they would be eligible for Medicare.
Thank you, Evelyn. And next question here is just what are the primary types of Medicare coverage that are available? Jasmine?
There are different types of Medicare coverage available. The first is traditional Medicare, which is Part A and B. We then have Medicare Part D, which is Medicare prescription plans. Next is Medicare Advantage, which also known as Medicare Part C, and this combines benefits of Part A, B, and D. Lastly, we have Medicare Supplement plans, which is also known as Medigap.
So Evelyn, how do Medicare Advantage plans differ from the Medicare Supplement, the Medigap plans? Are the recovery rights different, or how should these be approached?
So Medicare Advantage plans or Medicare Part C plans are actually replacements for Medicare. So a person would become eligible for traditional Medicare coverage, and then either they can have their bills sent directly to Medicare and have them paid that way, Or if they'd like to, they can get coverage through a private company that offers a Medicare Advantage plan. And when that occurs, then their medical bills would go directly to the Medicare Advantage plan. They would not go to Medicare first. So it actually serves as a complete replacement for the time that a person elects that coverage. They can change that coverage every year, and there's various reasons that they can switch from plan to plan. But while they're with a plan, then all of their bills get paid there. A Medicare supplement plan, on the other hand, really goes more with traditional Medicare. So while traditional Medicare would cover typically 80% of whatever claims they're covering, that additional 20% would be left over for the Medicare beneficiary. It would be their responsibility. And so they can elect a Medicare supplement plan to cover that 20%. So typically at any one time, a person can only have either a Medicare Advantage plan or they can have traditional Medicare plus a supplement plan. They also differ in terms of their recovery rights. So Medicare Advantage plans, because they operate as a substitute for Medicare, they are actually named in the Medicare Secondary Payer Act. So they have rights under the Medicare Secondary Payer Act, just like Medicare does. Medicare supplement plans, however, are not mentioned there, and so their recovery rights come from the contract that they have, state law, and any of those other ways that a private plan would have recovery rights.
Thank you, Evelyn. That was a lot of insightful information about the differences between those two types of plans. So when we are thinking about a Medicare beneficiary who has Medicare, can they change their plan during the life of the personal injury case? Like, might a personal injury attorney need to look at traditional Medicare and a Medicare Advantage?
Yes, a person's plan can change multiple times over the course of a case. So they can go back and forth between traditional Medicare and a Medicare Advantage plan. They can go between different Medicare Advantage plans. Medicare Advantage plans can go out of business. Medicare Advantage plans can pull out a particular county. So it can certainly change multiple times. Typically, it should only change about once a year. So there is an annual enrollment period that runs from October 15th to December 7th every year. During that time, a person can, very freely go between Medicare Advantage plans or go back to traditional Medicare. But there's also some special exceptions that allow people to move mid-year if they need to. So just because a person started out on traditional Medicare or with a particular plan does not mean that they have stayed there the entire time the case is pending.
Okay, so with that said, people can have different types of Medicare plans at different times throughout the life of the personal injury case. What if my client doesn't remember what type of plan they're enrolled in now or previously?
Yes, so you might have to play detective to get the answer to this question because it can be a little bit difficult. There, unfortunately, is no one hard and fast way to get that information. But one way would be to have the client log into Medicare.gov. And so if they log in there, they should be able to see both claims that have been paid, as well as whether they are getting paid through traditional Medicare or if they have elected a Medicare Advantage plan or multiple Medicare Advantage plans. That information should be there. It can be a little bit difficult to get, though, depending on the client's level of technical ability or how familiar they are with that website. So if you're able to sit with them to be able to click through and get the information that you need, that is a great resource. You can also check the medical bills and the records to see, if Medicare is listed there, or if it might say Medicare Advantage, or it might just say the name of the insurance company. It might say United or Blue Cross Blue Shield. And then that gives you a little bit more information to be able to try to hunt down who might have a lien. Another way, and I would recommend this for anyone who you are sure has Medicare or suspects may have Medicare, either because of their age or because they're receiving Social Security disability benefits or applying for Social Security disability benefits, report the case to Medicare. If they don't have a file on the person, they will send you a letter back that says that, and then at least you'll have a little bit more information there. Now, that said, just because a person doesn't have Medicare at the time you check doesn't mean that they won't become eligible for Medicare by the time the case resolves. So if you are reporting that pretty early in the case, you might want to go back later once you get closer to settlement and just send another letter to them, ask them to double check just to see if the person has become eligible for Medicare at some point. But if the person does have Medicare, then Medicare is going to respond, typically letting you know that they have opened up a case for the person or a file within their system. And basically what they'll do is they'll just start keeping an eye on claims and adding things that they think are related to the conditional payment letter. So then that gives you an idea of what is out there and what you may have to do with at settlement. And then lastly, though the insurance carriers or the defendants have access to some information from Medicare that unfortunately we don't have access to and plaintiff attorneys do not have access to, but they do have access to reporting through their Section 111 reporting requirements that can tell them if the person has been on a Medicare Advantage plan for the past 3 years. So they do have a way to get that information. Whether or not they're willing to share that information is a different question. But if you are on good terms with them, then you might want to ask and see if they can provide that.
So finding the correct Medicare plans is definitely important, but what other compliance issues should attorneys watch out for when they're settling a case that is involving a Medicare beneficiary?
There are 3 main things that you want to do to be compliant with the Medicare Secondary Payer Act. So the first one is addressing conditional payments, which means reporting the case to Medicare, letting them know what the applicable injuries are, and allowing them to start building that conditional payment letter. Certainly you should audit that, check to see if there is anything there that is not related, challenge those claims, try to get them removed. And then the other piece of that is reporting the settlement so that Medicare will turn that conditional payment letter into a demand. And then there are still other ways to get that reduced even after the demand is issued. And then the second thing we always recommend is making sure that you're aligned with the insurance carrier or with the defendant on what they're putting into their Section 111 reporting. So because they also have a responsibility to report these cases to Medicare, they also have to report a date of injury and injury codes related to the case, as well as the settlement information. So it is very important to make sure that everybody is aligned as to what those things are that are being reported so that Medicare doesn't receive conflicting information and then end up creating additional cases. So that is something that we see all the time in cases that we handle. So basically that the plaintiff attorney will have reported the case to Medicare, they have reported what they believe the date of injury is, what the injuries are, and then at some point defense does their reporting and they report something a little bit different. So maybe they report a slightly different date of injury, or maybe they report more injuries than the plaintiff attorney reported. But in any case, something is different. And so Medicare gets that information, they don't know how to reconcile it, and then you might end up with multiple cases. And unfortunately, these things can happen very far apart in time. So, because the plaintiff attorney typically is reporting that case earlier, probably before settlement or maybe around the time of settlement, the insurance carriers can delay their reporting. So they are supposed to report within about a year to avoid being fined, but they could potentially report late. We have seen insurance carriers report years after settlement. And unfortunately, that can be a huge headache because at that point, if funds have been dispersed and now suddenly you've got a new demand to deal with, that can be a really big issue. So one way to try to avoid that on the front end is to talk to defense counsel and try to get aligned on what they're going to report so that at least Medicare doesn't get a bunch of conflicting information that creates a situation with multiple files. And then the last piece, and Rasa is going to go into this in detail, but avoiding a post-settlement shift to Medicare. So basically what that means is if the person is still treating for their injury after the settlement, Medicare can potentially deny those claims. They're going to kind of keep a flag on the file where they're going to look for anything that looks like it might be related, and then they may deny it. So just make sure that you are considering what the options are at settlement. Again, Rasa will go into detail on that, but very important to make sure that Medicare's interests are considered.
Let's transition to the process for finding out what Medicare's interest is. So Jasmine, can you tell us how to initiate a Medicare conditional payment search so that we can know how much Medicare wants to be reimbursed for this personal injury case?
To initiate a Medicare conditional payment search, the first step is reporting the case to the BCRC. Now, there are a few different ways in which you can do this. The first one being reporting the case through the Medicare Secondary Payer recovery portal, which we find to be the fastest and most efficient way of doing so. But you can also report a case either via fax or phone. When you go to report a case, there are a few pieces of information that you'll need to have ready. So the injured party's name, their date of birth, either their social security number or their Medicare ID, the date of injury, and lastly, the injuries sustained in the accident.
What if you do all that and then you get the first conditional payment letter, and on it, it shows that there's no related paid claims, but you as the plaintiff attorney know that Medicare paid for a lot of this treatment that is accident related? What steps should you take?
Yes, so there are a few different things that you can look for when this occurs, because you definitely want to try to figure out if that conditional payment letter is zero or if it's even just substantially lower than you were expecting it. It's important to try to figure out why that's occurring and who might have paid those claims, or where might they be. And so one option, if the client is still actively treating, is that those claims just haven't been processed yet. So it does take CMS about 90 days to process a claim and get it onto a conditional payment letter. So if you're within that period, they're probably just not processed. So that's always a possibility. If you are using CMS's portal, you can ask them to update the case periodically. So there's an option there to ask them to update the conditional payment letter. They also will do this on their own periodically. They'll put the case into what they call a claim retrieval status. And that's when CMS is looking at the case to see if there is anything additional that looks like it's related that they've paid for, and that they might add to the conditional payment amount. You would also want to check to see if the information that CMS has is accurate. So by looking at, double checking the date of injury and then the injuries that have been reported, to make sure that what CMS has matches what it should be. There's different reasons why that can be wrong. Sometimes it can just be an error. So we handled a case recently where someone called in the case to CMS. Seems like they must have heard wrong or something, but they put the wrong information into the file and we're building their claim summary based on that. So always just going back and double checking that information, says what it should say, that it's got the right injuries and that CMS is actually scrubbing for the claims that you would expect them to. Another kind of related issue that can happen here is if there's multiple CMS cases. So we do see situations sometimes where, because there's multiple cases that are out there, they might have different claims on them. And like I mentioned before, this can happen for different reasons. It could be related to defense reporting. It could be that the client called some information in at some point. But we'll periodically check the portal and go back and search again by the date of injury, or just to see if there's anything else that's out there. If there are duplicate files, your client should know about that. They should be getting mail about that. And then, if you've ever been associated with the case through CMS, then they may be sending you those letters as well. But keep an eye on what those case IDs are, because that will tell you if you've got a second case that's been created, and that might be where the claims are sitting that you were expecting to see. And then lastly, whenever we have a lien that is lower than we would expect, it's always possible that there's another insurance plan that's paid for those claims. So, here we would look for a Medicare Advantage plan or something else, because Medicare Advantage plans claims are not going to show up on Medicare's conditional payment letter. They are two completely different systems. So the conditional payment letter only includes the things paid by traditional Medicare. If the person has a Medicare Advantage plan, then that Medicare Advantage plan, that private company, is going to be the ones who are maintaining that file, and they're the ones that you would need to check with to figure out if they have a lien.
So Jasmine, this next one is for you. We see here a lot at Synergy where plaintiff attorneys have a number from Medicare and then they settle their case and then they're surprised that the number becomes higher once they try to get the final demand from Medicare. So can a conditional payment letter be relied on before the case settles?
No, you should never rely on a conditional payment letter or a conditional payment notice. The only thing you should really rely on is a final demand. The reason for this is because Medicare can always sweep for more claims, including once settlements reported. So until you actually report settlement, Medicare does their final claims processing and they issue the final demand. Nothing can be relied upon.
What if we're about to settle the case and we have to know how much Medicare's interest is? If we can't rely on the conditional payment and have to get a final demand, but we can't get a final demand until we report settlement, how do we know how much Medicare is going to want when we're trying to settle this case?
Yeah, so Medicare has something called the final conditional payment process, which can be utilized in situations just like this, where you're about to settle a case and need to know how much Medicare will demand.
All right, Jasmine, so that sounds like a great option. How does it work? Tell us more about it.
So when you're within 120 days of your expected settlement date, you can enroll the case in the final conditional payment process. While you're within this 120-day stage, you can still submit disputes, but you are limited to one dispute per claim line. Additionally, CMS has to review any disputes within 11 days when enrolled in this process. Then, once you're within 3 days of your expected settlement date, you would go ahead and lock the case in the final conditional payment process. This will then allow you to generate a final conditional payment letter. The key part of this is that your case must settle within those 3 days. If it doesn't, you'll be kicked out of the process and unable to utilize it again. The last step of the process is that you must report the settlement to CMS within 30 days. All of these steps must be done through the Medicare portal in order for the process to be successful. If you complete all of these steps within the appropriate timeframes, CMS will not be able to add on additional claims post-settlement. The amount you locked in will be the final conditional payment amount, and CMS will still apply the procurement reduction after the fact.
So let's turn a little bit to taking a closer look at the conditional payment letter and the claim summary that follows it. What is it that you can do if you see that there are claims that are on there that aren't related to this case? How is it that you tell Medicare that they're asking for reimbursement for things that they shouldn't be asking for reimbursement for?
There are a few different ways you can submit a dispute to CMS. So one way is via fax, another is via mail, and then the last way, and the way we use because we find it to be fastest and most efficient, is using the Medicare Secondary Payer recovery portal. So through the portal, you can download claims listings directly in Excel. This makes it easier to mark them up. You can also upload supporting documentation directly through the portal. So oftentimes we find when disputing claims with CMS, it's helpful to include supporting documentation such as medical records or expert reports. So CMS has up to 45 days to review these disputes, although we don't often see it take the full 45 days, but it can vary depending on each case. The last thing is that you can dispute these claims unlimited times while it's not settled. So up until settlement's reported and you have that final demand, your dispute attempts are unlimited. This is good to know because sometimes you may file a dispute which comes back unfavorable, but you can go ahead and file another one, this time maybe including some additional supporting documentation, and Medicare will review it again and there might be a different outcome the second time around.
Evelyn, please tell us, are there any risk if you fail to resolve the Medicare conditional payment?
Yes, so there are some different risks that can occur if you do not report the case to Medicare. So it's really important to remember that even if you don't report the case to Medicare, that there are some other ways that they could find out about the case. So the main one is through the defense or insurance carrier's Section 111 reporting, which is something that they are required to do. They also can be penalized or fined for not doing that reporting timely. So while they maybe were not as good about doing this in the past, we are starting to see them get a little bit faster and do this a little bit more reliably. So it's definitely a big risk that even if you don't report the case, Medicare may find out about it from another party. They can also find out about it from a provider, potentially. So if your client is getting treatment at some point, they mentioned that they were in a car accident, if that information makes it into the billing records, then potentially Medicare is going to realize that, oh, hey, there was a case here and that, maybe there's some money for them to recover. And so typically what will happen when Medicare is being notified by the insurance carrier is it because they're being advised of the settlement occurring, they will just go straight to issuing the demand. So while if, as a plaintiff attorney, if you report the case to Medicare early, you're going to have a conditional payment letter out there, but nothing's really going to happen with it. That money is not due yet, and that conditional payment letter will just kind of stay there until somebody reports settlement. But again, because the insurance carrier is reporting that the case has settled, Medicare is just going to issue that demand right away. And so they may not even send it to you as a plaintiff attorney. If they don't know that you're involved in the case, that letter is probably going to go directly to the client. They may not know what to do with it. If the client has passed away, that letter could go to an address where, either the person getting it doesn't know what to do with it, or, maybe no one even associated with the family lives there anymore. And if Medicare doesn't receive that letter back, then they just assume that it was delivered. So after 60 days has passed and it has not been paid, they'll start to add interest, and then eventually they can refer the case over to the Department of Treasury for enforcement. So, unfortunately, we see cases like this sometimes where demands were issued, potentially years in the past, no one knew about it, and now they've got thousands and thousands of dollars that have accrued in interest. And unfortunately, it's very difficult to get Medicare to remove that because, again, if they didn't get that letter back, they just assume it was delivered properly. And so they typically don't see a reason to remove that interest. And then most importantly, the Medicare Secondary Payer Act outlines who Medicare can pursue to try to get a demand paid. So they can pursue double damages, and they can go after any party that handled the funds. So that includes law firms, that includes insurance carriers, it includes providers potentially. It can include a bunch of different people who are associated with the case, but very important to remember that, especially if this happens years after the fact, funds have been dispersed, you could potentially have Medicare coming after you for double damages. So it's very important to make sure that all these issues are addressed and that doesn't occur.
So when we're talking about the Medicare conditional payment letter and the amount that is on that letter, does that also include claims that would have been paid by a Medicare Advantage policy at some other time? Is it all included on the same claim summary?
No, Medicare conditional payment letters do not include Medicare Advantage lien amounts. Medicare Advantage liens are handled completely separate to traditional Medicare liens. Advantage liens are handled directly with the subrogation vendors.
Okay, so if the Medicare Advantage claims that were possibly paid 1 year are not on the conditional payment letter with traditional Medicare that paid on another year, how is it that the Medicare Advantage plan should be addressed?
Like with traditional Medicare, Medicare Advantage claims should also be audited to make sure everything is related to the underlying case. Additionally, most of the subrogation vendors will provide a procurement reduction if requested. Sometimes you will experience some pushback from certain vendors, but usually we challenge their position and are able to secure a reduction for fees and costs. Lastly, you should utilize hardship arguments or specific case facts to push for a greater reduction beyond the unrelated claims and procurement reduction.
So Evelyn, we talked about what can happen if traditional Medicare isn't resolved, but what about these Medicare Advantage liens if they're not found or resolved? What compliance issues might exist there?
So under the Medicare Secondary Payer Act, Medicare Advantage plans have the same rates of recovery that Medicare has. So they can also pursue double damages for an unpaid lien. How they do that looks a little bit different than when Medicare does it. So Medicare, because they're part of the federal government, they can use the Department of Justice to bring their claim. They can use the Department of Treasury to try to recover money from a person's Social Security check or from a tax refund. So Medicare Advantage companies, because they're private companies, they don't have those kinds of options, but they do have a private cause of action under the Medicare Secondary Payer Act that allows them to bring a lawsuit to try to recover those funds. And then when they do that, they obviously are not going to provide any kind of procurement cost reduction or anything like that. So even though the process looks a little bit different, it is a very similar risk in that that demand may still catch up with you and they could potentially get double damages.
All right, so thank you, Evelyn, for that explanation. What about these Part D prescription drug payments? Do they need to be addressed, and where do they fall under needing to be complied with?
Yes, so prescription drug plans or Part D plans are also considered as part of the Medicare umbrella. So just like Part C plans, they also have a right of recovery under the Medicare Secondary Payer Act. And like Part C plans, they are operated by private companies. So their claims would not show up under traditional Medicare's conditional payment letter. You would have to reach out to that company directly and request their lien.
Thank you, Evelyn and Jasmine, for all of those answers. We're going to shift a little bit, and Rasa is going to be the main question answerer at this point. So, Rasa, what is Section 111 mandatory insurer reporting? I think we heard about it from Jasmine or Evelyn just a minute ago. What more can you tell us?
Mandatory insurer reporting, or Section 111 reporting, serves as the enforcement mechanism of the Medicare Secondary Payer Act. It gives Medicare information so that they could recover improper payments that were made. Those are the conditional payments they're looking to be reimbursed. And it could also help Medicare to avoid making improper payments in the future. So when you have a settlement, whether it's liability, workers' comp, or no fault, and the settlement involves a Medicare beneficiary, and the settlement involves a physical trauma and is over $750, the defense, through their responsible reporting entity, will report the settlement, or TPOC, total payment obligation to claimant, to Medicare. A failure to report to Medicare by the defense's RRE can result in civil money penalties. This is going to happen via an audit of the Section 111 reported files. If Medicare were to see that there's a pattern or the carrier is failing to report these settlements in a timely manner, they will be hit with steep penalties. The penalties are really sort of the driving force behind defense attorneys who are being a bit more aggressive when it comes to Medicare secondary payer compliance terms in settlement documents and the posture that they're taking in the cases. Mandatory insurer reporting now also has a field for the reporting of workers' compensation Medicare set-asides. This is something that is new. They do not have a field at this time for liability Medicare set-asides, and it's questionable whether they will, but this is something that they're pursuing in the workers' comp space. We recommend that you have a discussion with the defense so that you can be aligned in terms of the date of the settlement that is being reported to Medicare, the date of the accident, and most importantly, the diagnosis codes that are going to be reported to Medicare. A failure to be aligned with Medicare, with the defense, for example, on the diagnosis codes, could result in Medicare looking to be reimbursed for conditions where truly they are the main payer, or it could result in your client having potential issues with Medicare, questioning whether they're the primary payer for these diagnosis codes that were incorrectly reported to Medicare.
And so, Rasa, we've talked about the claims that Medicare has paid in the past prior to settlement, but what should an attorney do if their client is going to need an injury-related surgery after the settlement?
When you have a settlement and your client, the injured party, is likely to require future injury-related care and they're on Medicare, we recommend that you have a discussion with them about the potential impact of the Medicare Secondary Payer Act on their future injury-related care. As we just talked about, when there's this mandatory insurer reporting that takes place and Medicare knows about a settlement and the conditions that were compensated in the settlement, there's a possibility that Medicare might deny post-settlement injury-related care, pointing to the settlement. Now, Medicare, if they were to do this, would not necessarily, be denying all post-settlement injury-related care. This might be a situation where an analysis letter could be prepared that shows that this settlement is just simply insufficient to fund anything for futures, meaning that the past medical bills are so high and you have a policy limit settlement. So clearly you are not cost shifting post-settlement injury-related care to Medicare. You might also have a situation where the treating physician has concluded that the injury-related care is finished, no further injury-related care is indicated. In that situation, even though you have a settlement, and even though treatment might be occurring to that same body part, Medicare should be responsible for it because it is no longer injury-related care based on their treating physician's written certification. If you have a situation where the settlement does include compensation for future medical and your client plans to receive future injury-related care, the most prudent course of action because of that Medicare Secondary Payer Act would be to set aside a portion of the settlement as a Medicare set-aside. Your client, of course, does not have to do any of this, but the most important part is that they are able to make an informed decision on how much or how little risk they're willing to assume when it comes to these potential issues with Medicare.
Wow, thank you, Rasa. That's a lot of information and definitely a lot that an attorney needs to consider if there is future treatment that's needed. So does a liability Medicare set aside fund the future treatment at the Medicare fee schedule or something else?
Anybody who has negotiated conditional payment demands with Medicare or has reviewed a payment summary form for Medicare knows that the amount of money they pay to a provider is significantly less than what that provider would charge a regular, group health insurance plan, or they would charge a patient. So because of that very reduced rate, we oftentimes get a question about whether Medicare set-asides, these future medical allocations, whether they're priced out at the Medicare fee schedule, which would make sense given the fact that Medicare gets such a huge discount. This, however, was something that was addressed by Medicare ages ago when they were talking about the guidance that they're giving in workers' compensation cases. And the same logic applies to liability cases as well. A provider is only willing to accept that reduced fee schedule because they have a contract with Medicare. An individual who goes in for medical treatment cannot force the provider to bill them at the Medicare fee schedule rate. Because of this, these Medicare set-asides are priced out at the usual and customary charges for the geographical area.
What if the liability MSA takes up most of the settlement?
When we have discussions with Medicare beneficiaries who will be requiring post-settlement injury-related care, one of their main concerns is that if they get a Medicare set-aside recommendation that is going to project future injury-related care that's covered by Medicare for life, and if they fund that dollar amount, that they're not going to have anything left in their settlement. And that truly is a very legitimate concern. Because when you do have a Medicare set aside, it is projecting treatment that is reasonably likely to occur over life. And that essentially is 100% funding of the future medical. Liability settlements, though, do not fund anything 100% because you have policy limits, you have all sorts of disputes. So what we do is we offer a reduction analysis which looks to the ratio between the total potential case value and the injured party's actual net settlement after attorneys, fees, costs, and liens are deducted. So if an individual is only, let's say, recovering 10% of the total potential case value, we would apply that percentage to the Medicare set-aside number to come up with an equitable apportionment of how much of those settlement funds should be earmarked into a liability Medicare set-aside.
So for someone who doesn't know anything about MSAs and how they work, do you prepay the MSA amount to Medicare?
In 2012 or 2013, Medicare came up with proposed rules for liability Medicare set-asides where they had around 7 different options that they were floating out there. One of them involved the concept of an individual who is on Medicare that is settling their case and is going to need future injury-related care to put aside a specific dollar amount, give it to Medicare, and have Medicare sort of draw from that account from instead of looking for the individual to have a Medicare set-aside account, basically you'd be prepaying that MSA to Medicare. That is not something that has ever happened, nor do we anticipate that it will ever happen. If a person has a Medicare set-aside fund that they're setting aside from their net settlement, they are going to either self-administer that account, meaning they manage the funds by putting them in a separate interest-bearing account at the bank, or they could choose to have professional administration by a company that does this, where you pay a one-time lifetime administration fee. The funds are put into an account, and that account and the bills are administered by a professional. So there is no prepayment of the Medicare set-aside account to Medicare.
All right, so Rasa, what does a waiver of the private cause of action mean? What can you tell us about that?
Medicare Secondary Payer compliance terms will usually involve a provision that talks about a waiver of the private cause of action. Private cause of action is set out in the Medicare Secondary Payer Act, and it basically allows private parties to sue primary payers, meaning insurers or employers, for double damages if they fail to reimburse Medicare for conditional payments. So, for example, you may have seen situations where Medicare Advantage plans are looking to get reimbursed from settlements by pursuing the plaintiff firms, by pursuing employers, and other potential primary payers. Now, the waiver just wants to ensure that your client is not going to go after the insurance carrier for double damages for failing to address the reimbursement of conditional payments, if that is something that they agreed to.
So Rasa, when an attorney is looking to settle the case and they are given the release, what is it that they should be looking for in the MSP compliance section of that release to make sure that they're covered in the right way?
When reviewing Medicare Secondary Payer compliance terms, it's important to cut through all the mumbo jumbo and boilerplate language that you might see in a document to focus on conditional payments. It's helpful to see whether the defense has added conditions that simply cannot be met, such as obtaining CMS review of a liability Medicare set-aside. It's also important to see whether the terms truly reflect your agreement when it comes to post-settlement injury-related care, for example. We have seen people put in settlement terms that include the diagnosis codes that will be reported to Medicare. That is something that serves a purpose to make sure that everybody's on the same page. So when you do get these 4 pages of MSP compliant settlement terms, do review them carefully to make sure that you can comply with the terms, and for the most part, get rid of things that have no business in the settlement terms when it comes to MSP compliance. You might see inconsistencies because you have attorneys that have thrown in conflicting boilerplate terms for different types of settlement.
So Rasa, if we were to try to summarize, what strategies should personal injury attorneys implement to ensure that there's proper case management and avoid all these Medicare-related pitfalls that could happen? What is best practice?
When it comes to best practices for cases involving Medicare beneficiaries or those who will be on Medicare at some point during the negotiating of the case, it's important to have a system. You should have an intake screening to see whether people are on Medicare. or if they applied for Social Security disability benefits when they came into your office. You should also update this process if you've had this case for a year or two to see what the individual's Medicare status is. It's much better to address this early on than be scrambling at mediation when it comes to this. We also recommend that you begin the conditional payment search as soon as you've identified that the individual is on Medicare and a case has been established. You can dispute unrelated conditional payments before you get a final demand. It's also important that you have a discussion about mandatory insurer reporting with the defense to make sure that you are both aligned in terms of the date of the settlement agreement, the date of the accident, as well as the diagnosis codes. When you do have a settlement with a person who is on Medicare or will be and is likely to require ongoing injury-related care, we recommend that you have a discussion of the Medicare Secondary Payer Act and the potential impact of Medicare's status as a payer of last resort with your client to make sure that they can make an informed decision on how much or how little risk they're willing to assume when it comes to potential issues with Medicare. It's important to document your file about these discussions so that if there were an issue a few years down the road, you and your client would be on the same page in terms of remembering the discussions that you've had. We do recommend that you are proactive when it comes to MSP compliance. Synergy is here to assist you with any of your MSP compliance needs. Thank you for your time.
Hi, this is Jason Lazarus, founder of Synergy. Thank you for attending today's Synergy Insight presentation. Before we conclude, I wanted to take a moment to tell you a little bit about our team pictured on your screen right now. Synergy is a mission-focused organization dedicated to improving the lives of the injured as well as their families, and freeing trial lawyers and their firms to focus on what they do best. We all care about this mission deeply. I am so proud of our incredible team that works tirelessly each day to get the best possible results for you and your clients. It's why Synergy has been consistently recognized as one of the fastest growing companies in the US. Contact us today to find out about forming a strategic partnership with Synergy that will transform the efficiency and profitability of your practice.